The Department of Justice has established a new strike force to investigate the origins of the Trump-Russia collusion narrative. This move comes in direct response to a series of declassifications by the Director of National Intelligence, Tulsi Gabbard, which suggest that top officials in the Obama administration may have been involved in creating the narrative. The DOJ announced the formation of the strike force Wednesday evening, stating its purpose is to assess the recently publicized evidence and determine potential next legal steps. Attorney General Pam Bondi affirmed the department's commitment, stating, "We will investigate these troubling disclosures fully and leave no stone unturned to deliver justice." The strike force will be comprised of investigators and prosecutors from various divisions, including the National Security Division, and will focus on potential offenses such as making false statements and other fraudulent activities. This development is the latest in a series of revelations that have reignited the long-standing controversy. The catalyst appears to be the evidence declassified by DNI Gabbard, suggesting that Obama administration officials manufactured and politicized intelligence to build the case that Russia was interfering in the 2016 election to help Donald Trump, allegedly, despite conflicting information from within the intelligence community. The declassified documents name former President Barack Obama, then CIA Director John Brennan, then DNI James Clapper, and then National Security Advisor Susan Rice, among others. This follows a criminal referral sent by Gabbard to the Justice Department earlier this week. The situation has also intensified with the FBI opening criminal investigations into both former CIA Director John Brennan and former FBI Director James Comey. The inquiries stem from a declassified review of the 2017 Intelligence Community Assessment, or ICA. That review found that the process of creating the assessment, which concluded Russia had interfered to help Trump, was rushed and contained procedural anomalies. Critically, it found that the decision to include the now discredited Steele dossier in the assessment ran counter to fundamental intelligence tradecraft. The dossier, a collection of unverified and salacious claims, was funded by the Hillary Clinton campaign and the Democratic National Committee. The new investigations add another layer to information that has emerged over the years. Declassified transcripts from 2017 House Intelligence Committee interviews revealed that top Obama officials, including James Clapper and then Attorney General Loretta Lynch, testified they had not seen any direct empirical evidence of a conspiracy between the Trump campaign and Russia. In his testimony, Clapper stated, "I never saw any direct empirical evidence that the Trump campaign or someone in it was plotting, conspiring with the Russians to meddle with the election." Similarly, Susan Rice testified that she did not recall any intelligence she would consider to be evidence of a conspiracy. In a rare public statement, a spokesperson for former President Obama called the new allegations outrageous, ridiculous, and a weak attempt at distraction, affirming the widely accepted conclusion that Russia worked to influence the 2016 election. Turning from the executive branch to the nation's highest court, the Supreme Court has stepped in on a critical voting rights case. On Wednesday, the court issued an emergency order that temporarily blocks a lower court ruling that had prevented private citizens and civil rights groups from suing over alleged racial discrimination under the Federal Voting Rights Act. The ruling in question came from the U.S. Court of Appeals for the 8th Circuit and applied to 7 states: Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. In a significant departure from decades of legal precedent, the 8th Circuit had concluded that only the U.S. Attorney General has the authority to file lawsuits under Section 2 of the landmark 1965 Voting Rights Act. Section 2 is a crucial provision that prohibits any voting practice or procedure that results in the denial or abridgment of the right to vote on account of race. For nearly 60 years, this section has been enforced primarily through litigation brought by private individuals and organizations like the NAACP and the ACLU. The Eighth Circuit's decision threatened to eliminate that enforcement mechanism entirely within its jurisdiction. The Supreme Court's unsigned order puts that controversial ruling on hold while the legal battle continues. The case, known as Turtle Mountain Band of Chippewa Indians versus Howe, was brought by a Native American tribe and a tribal organization in North Dakota. While the stay is temporary, it is a significant, albeit preliminary, victory for voting rights advocates who argued the Eighth Circuit's ruling would have dismantled a key pillar of civil rights law. In Washington, President Trump has signed into law a new bill aimed at cutting federal spending. The legislation rescinds a total of $9 billion in previously appropriated funds. The package includes a $7.9 billion clawback of funds designated for global aid, which were under the purview of the now defunct U.S. Agency for International Development, or USAID. The responsibilities of that agency have since been absorbed into the State Department. The bill also eliminates $1.1 billion in funding for the Corporation for Public Broadcasting. This cut directly impacts National Public Radio, or NPR, and the Public Broadcasting Service, PBS. The move aligns with long-standing criticism from conservative circles and the Trump administration, which have accused both organizations of exhibiting a liberal bias in their programming. An earlier version of the bill had proposed an additional $400 million cut to PEPFAR, the President's Emergency Plan for AIDS Relief, a widely praised State Department initiative that combats HIV and AIDS globally. However, that provision was stripped from the final version of the bill that President Trump signed, signaling continued bipartisan support for the program. Now to a development in a high-profile federal case in Florida. A federal judge has ruled that Ryan Routh, the man charged with attempting to assassinate former President Donald Trump in September 2024, will be allowed to represent himself at his upcoming trial. U.S. District Judge Aileen Cannon granted Routh's request on Wednesday, but stipulated that his court-appointed federal public defenders must remain on the case as standby counsel. This means they will be available to provide legal assistance if Routh requests it, or if the judge later revokes his right to self-representation. The ruling came after his lawyers filed a motion to be removed from the case, stating that Routh had refused to meet with them on multiple occasions. Prosecutors allege that the 59-year-old Routh entered the grounds of the Trump International Golf Club in West Palm Beach with the intent to assassinate Trump, who was the Republican presidential nominee at the time. The trial is scheduled to begin in September, marking 1 year since the alleged incident, which was the second attempt on Trump's life in 2024. Finally, the Justice Department is escalating its battle with so-called sanctuary jurisdictions, filing a lawsuit against New York City. The civil suit, filed against the city and its mayor, Eric Adams, seeks to overturn local laws and policies that make New York a sanctuary for foreign nationals from federal immigration enforcement. This legal action is a key component of President Trump's agenda to curb illegal immigration and end the practice of cities and states refusing to cooperate with federal authorities. The lawsuit specifically targets provisions in the city's administrative code and New York Police Department directives. These rules largely prevent the NYPD from cooperating with U.S. Immigration and Customs Enforcement, or ICE, on matters of identifying, detaining, and removing immigrants who are in the country illegally but have not committed other serious crimes. The federal government argues in its lawsuit that these local policies are unconstitutional. The Justice Department's central claim is that the city's laws violate the Supremacy Clause of the U.S. Constitution, which establishes that federal laws take precedence over conflicting state and local laws. The suit represents a major escalation in the ongoing conflict between the Trump administration and sanctuary jurisdictions across the country over the enforcement of federal immigration law.